Today we will talk about the Sixth Amendment to the United States Constitution. The Sixth Amendment reads, "In all criminal prosecutions, the accused shall enjoy the right to a speedy and public trial by an impartial jury of the state and district wherein the crime shall have been committed, which district shall have been previously ascertained by law, and to be informed of the nature and cause of the accusation, to be confronted with the witnesses against him, to have compulsory process for obtaining witnesses in his favor, and to have the assistance of counsel for his defense." When I use brown text, it's a direct quote from the document. So this consists of these elements: a speedy and public trial, an impartial local jury trial, the right to know what the charge against you is, and the right to confront witnesses against you and cross-examine them, and to compel witnesses to appear in your favor, and the right to have a lawyer. So let's take these one at a time. First, a speedy trial. The Magna Carta was written in 1215 states, "To no one deny or delay right or justice." So even back in 1215, they understood that you shouldn't delay justice, that a speedy trial was important. Kings might imprison their enemies without trial just to keep them quiet. So to avoid this, the Speedy Trial Clause works together with the right of habeas corpus, which is from Article 1, Section 9, Clause 2 of the Constitution, which says, "The privilege of the writ of habeas corpus shall not be suspended." Now, most of us don't speak much Latin, so what does habeas corpus mean? Habeas corpus means essentially to have the body. So when a prisoner says I'm being wrongly imprisoned, they assert their right of habeas corpus. So then the prisoner is brought before the judge. So the judge has the body, has the person standing in front of them, and will judge whether their imprisonment is lawful or not. So if you're being held unlawfully, the judge should free you, but if you're being properly held, then the judge should say, okay, you can go back to jail and await your trial. So habeas corpus is having the body, having the right to appear before a judge to decide whether your imprisonment is lawful or not. And also the Eighth Amendment, which says excessive bail shall not be required. So having a speedy trial, the right to determine whether you're properly imprisoned, and not having excessive bail altogether would prohibit abuses like a king or a government imprisoning their enemies without a trial just to keep them quiet or keep them out of their way. So a speedy trial helps minimize pretrial detention, but it also applies even if the defendant is out on bail. So if you're held in jail before your trial or if you're on bail, both cases you still have a right to a speedy trial. In the case Barker versus Wingo in 1972, the Supreme Court made a 4-element test for whether you have been denied this right to a speedy trial or not. It consists of whether and how the defendant asserts his right to a speedy trial. So if the defendant doesn't mind the delays, maybe it's helpful to the defense, and doesn't say, hey, we need to move this along, then that counts against on this test. The length of the delay, the reasons the prosecution gives for the delay, and also the harm the defendant suffered from the delay. Perhaps there was a key witness for the defense and that witness died. So, that's a problem. That would be a harm the defendant had suffered from the delay of the trial. Also, people's memory fades over time, and so people might not be able to remember as clearly what went on and hence testify to that. So, a defendant can be harmed from a delay of the trial. So this is a 4-pronged test. So if one or two of these elements is pretty strong, maybe the others can be a little weaker and still qualify under this test for a speedy trial. So the ultimate cure for not having a speedy trial is to prohibit prosecution. The courts usually don't want to go there, but if it's been too long and there's no good reason, the court could just say, sorry, you can't prosecute this person. You've violated their right to a speedy trial. A public trial is the next right. So secret courts, such as the Star Chamber in England, which was just a court that had stars on the ceiling, so they called it the Star Chamber. But it was a secret court used by the king to punish his enemies. In 1607, Sir Edward Coke said in a trial is almost by definition open and public. So common law required trials to be open to the public. And so having a right to a public trial is a right of the defendant. It's a protection for the defendant. Also, the public and the press have an interest in public trials under the First Amendment to observe and discuss government affairs. Courts and trials being part of the government, that's one part of the government that the public has the right to observe and discuss their government affairs. And also so they have confidence in the process that it's being done properly. Portions of a trial may be closed to an audience, say to protect a minor in witnessing in a sex offense case, or the identity of an undercover witness. So there can be reasons why a trial might be closed to the public, or at least for a short time. But generally, they should be open to the public because open trials help keep everyone responsible and truthful. The judge, the lawyers, the witnesses testifying, it just keeps everyone honest. Also, you have a right to an impartial and local jury trial. The Sixth Amendment again says, in all criminal prosecutions, the accused shall enjoy the right to a speedy and public trial by an impartial jury of the state and district where the crime shall have been committed. So the Magna Carta states that no one will be punished except by the lawful judgment of his equals, or the judgment of your peers, sometimes it's said. So the Magna Carta is called, it means the Great Charter, and it dates back to 1215 when a group of nobles within barons within England were upset with the misrule of King John, and they had enough military power to force him into an agreement with the barons saying that there will be limits on the king's power. So they listed 63 or so different limits on the king's power. And this was the first time when kings were not absolute, where a king's power was limited. And it's the beginning of the path that we've gone down to representative democracy today. The British Parliament started with this group of barons, which would today be the House of Lords. So this was the time when representative republics were forming. So we kind of date our form of government back all the way to Magna Carta in 1215. So in English common law, jury trials set apart the English common law from the continental law. If you were on the continent of Europe, say in a French court, the judge would decide whether you were guilty or innocent. There would be no jury. But in England, they had jury trials. And jury trials are another way to separate powers. We have separation of executive, legislative, and judicial. That's one separation of power. Another is federal, state, and local. It's another separation of power. And here too, you're separating decisions of guilt or innocence. You're not giving that to a government official like the judge. They're put in the hands of ordinary people, just like you and me. And so this is another way that the founders were separating powers, not giving all power to the king or a central government. Another fact of jury trials is called jury nullification. So normally juries decide questions of fact. Did this person rob the bank or not? That's a question of fact. If they did, they're guilty. If not, they're innocent. But do they also decide issues of law? Is it wrong to rob a bank? Most of us would say yes, but say back in colonial America, there were seditious libel laws. And a lot of the juries would hear evidence, and even though the person might have been guilty of breaking that law, the jury said, this law is not right. We disagree with the law. So they would be deciding an issue of law and decide, okay, we don't like this law, so we're going to declare the person not guilty, even if they did in fact break that law, but the jury is saying this law is wrong. So that's called jury nullification. That was common back in America, not in England, but in America during colonial and early American times. In the later 1800s, it kind of swung more towards juries are only deciding fact. The judge could say what the issue of law means, but not the jury. But even today, if you're not too open about it, juries can still decide to declare someone not guilty because they disagree with the law, and that's called jury nullification. Also, the jury should be impartial. According to the case Irwin versus Dowd in 1961, a juror must be able to lay aside his impression or opinion and render a verdict based on the evidence presented him in court. So you don't have to be entirely ignorant of the facts of the case, but you have to be able to set aside any impression or opinion and only look at the evidence presented in court to make your verdict. And plea bargains, where you say you're guilty of, or you're accused of one serious charge, and they say, well, if you plead guilty to a lesser charge, we won't put you on trial. We'll just say, okay, you plead guilty to this lesser charge, and you'll take the consequence of that. So that used to be very rare, but now more than 94% of all felony convictions are plea bargains. And of that small bit that are left that actually go to trial, only about half of those are jury trials. So although the Sixth Amendment starts in all criminal prosecutions, this all criminal prosecutions has become very few now, almost none maybe. There are some jury trials, but very few in number. It used to be, even as late as the 1890s, where a court might have, half a dozen jury trials in a day. So you'd have an hour, you'd have the jury, the evidence, they'd go off and make their decision, next come in, and you'd do half a dozen trials in a day. Whereas now jury trials last on and on and on. So because they last so long, we have many fewer of them. And the jury should also be local, not in some centralized location. Another way to divide power. It should be somebody, should be people in your local community. Sometimes due to publicity, they might move the location of a trial, but generally trials are to be done in the place where the crime was committed, the state or the district. So say maybe the county. So, you're to be tried by your local community. So it's supposed to be local, not centralized. The arraignment clause says to be informed, you have the right to be informed of the nature and cause of the accusation. So here again, common law, English common law, going back as far as the 12th century, even a little before Magna Carta, developed an accusatory system based on specific charges, as opposed to the inquisitorial system based on Roman law and used in the church. So you've heard of the Inquisition, the Spanish Inquisition. That's this inquisitorial system where you would ask people many questions and you'd be fishing, looking for something to charge them with. So if you ask somebody enough questions, maybe you'll come across something they did wrong. And then you'll say, that's what you did wrong. All right, we're going to put you in prison for that. As opposed to the accusatory system, common law is that you have to have a specific charge ahead of time. You can't be fishing and just see what you'll find and then charge people with that. You have to say, this person burglarized this house on this date. And then you ask questions to see, did that actually happen? The trial is based on that specific charge, not just on some fishing expedition where they just keep asking you questions until they find something you did wrong. That's the inquisitorial system. So that's a protection, that you have to have a specific charge. And stating the charges also allows one to prepare a defense and also for the court to determine if the charge is specific enough. You can't just be charged with, he did something wrong about this time. It has to be very specific, what law was broken, when it was broken. You can't be a vague charge. The confrontation clause says you have the right to be confronted with the witnesses against him. So back to Magna Carta again, in 1215, it says, in future, no official shall place a man on trial upon his own unsupported statement without producing credible witnesses to the truth of it. So here we see having credible witnesses in a trial is very important to establish the truth of one's guilt or innocence. Also from Deuteronomy 19:15, one witness is not enough to convict anyone accused of any crime or offense they may have committed. A matter must be established by the testimony of 2 or 3 witnesses. So here we have 2 ancient sources saying that you have to have credible witnesses, you have to have multiple witnesses. If you have multiple credible witnesses, you have a much better chance of getting to the actual truth of the matter and finding out, was this crime actually committed or not? And this adversarial system allows the accused to both see and hear the witnesses against them. So you see who's witnessing, who they are, what they're saying, and you can also confront them. You can cross-examine them. Maybe a witness says something and you think that's not really what happened. So you can cross-examine. You can say, how was it that you could see what you said you saw? Where were you? What were you doing? Was it possible for you to see that? Also, is this person credible? Do you believe them? Do they have a habit of lying all the time? So you can cross-examine them to see, is what they're saying actually the truth? And, it's up to the jury to decide the truthfulness of different witnesses and weigh this evidence to decide guilt or innocence. But being able to cross-examine the witness is a better way to get at the truth rather than just accepting someone's statement and not being able to question them about it. Now, are there limits to confronting witnesses? There are some limited ones. Say a child testifying in a sexual abuse case. There was one case where a child was witnessing against their alleged abuser, and emotionally they were unable to do that in being in the same room with the person. So they set up a closed circuit TV camera where you could see the child and you could see how they looked as they were testifying, and they could be asked questions, but they didn't have to be in the same room. So sometimes in special cases, the court might set up some limit on that. But generally, you have to be present in the same room and be able to ask them questions. Another question is, when can hearsay be used? So hearsay is when I heard so-and-so told me this, and then I say it. Well, I didn't see it, but somebody else saw it. So a witness generally can't say just hearsay, but has to say what they actually observed, what they personally witnessed. And this confrontation clause was designed to limit the use of just depositions or affidavits, which would be a sworn statement taken outside the court and brought to the court and said, Mr. X said this. That had been abused in vice admiralty courts in colonial America in the 1760s, where the witnesses signed a statement and said, well, I say this, but you didn't have the chance to cross-examine them to see if what they were saying was truthful or to get more details on it. So that's why this confrontation clause is important. The compulsory process clause, we have the right to compulsory process for obtaining witnesses in his favor. So many of the prior clauses date back as far as the Magna Carta, but this one, until 1695 in England, an accused was not allowed to call witnesses in his defense in cases of treason or felony, or was forbidden to have them testify under oath. So back in 1670, when you were not allowed to call witnesses in your own defense, William Penn was arrested for teaching his dissident religious views to an unlawful assembly of Quakers. So he defended himself in court. He didn't have a lawyer, and he could not compel witnesses in his defense. And eventually the judge silenced him and removed Penn from the proceedings. So there was no one representing him, no one for witnesses on his side. Apparently he lost the case. So it's unsurprising that William Penn, who was the founder of the state of Pennsylvania, the colony, and then the state of Pennsylvania, in 1701 wrote in Pennsylvania's Charter of Privileges that all criminals shall have the same privileges of witnesses and counsel as their prosecutors. So he said the tables have to be equal. We can't have, the prosecutor having all the advantages of witnesses and lawyers and the defendant having none of that. He said to have a proper case, it has to be equal. The defense also has to have witnesses and legal counsel, a lawyer. And you have the right to subpoena witnesses, not just ask people to come, but to be able to force people to come to court to witness on your behalf. It's not telling them what they have to say. They need to say what the truth is, but you can force people to come to the court and to witness. So by subpoena. So that's why it's a compulsory process. In the case of United States versus Burr in 1807, Aaron Burr, who was a former vice president under Thomas Jefferson, was on trial for treason. And the Chief Justice John Marshall was the judge presiding. He said this compulsory process also included documentary evidence, the same subpoena power as the prosecution, and it could be used before indictment. So this expanded this right. So it's not only the right to compel witnesses to come in and say what they saw, but to get documents from, in this case, it was the government, he said, had documents that would help exonerate him. So he could subpoena documents as evidence. So that expanded this right. And finally, you have the right to a defense lawyer. So the amendment concludes you have the right to the assistance of counsel for his defense. Counsel would be a lawyer. Under English common law, those accused of felony could not be represented by a lawyer except for debatable points of law. After the Glorious Revolution in 1688, defendants against treason charges were allowed to have counsel, but not felony charges. So the Founding Fathers, although we inherited a lot of English common law, they didn't just take the whole of it without questioning. They said, here, this isn't right. And they explicitly extended this right to counsel, to a lawyer, to all criminal proceedings. So they decided, English common law was wrong in this case. Much of it they accepted and was good, but in this case they decided it was wrong, and they said anyone accused of a crime should have the right to hire a lawyer. So when the Bill of Rights was adopted, most people would represent themselves. They didn't tend to use professional lawyers very often, maybe in very serious cases, but most cases they didn't. People would just be their own lawyer. But during the 1800s, using a professional lawyer became more common. And so then the question arose, okay, well, what if you can't afford a lawyer? If you can afford a lawyer, you have the right to it. But what if you can't afford the lawyer? So is it a right to a lawyer even if you can't afford it? The case of Gideon versus Wainwright in 1963, Clarence Gideon was accused of burglary of a pool hall, I think, pool room. And he said, I can't afford a lawyer, can the state appoint one? And they said no. So he tried to defend himself and lost his case and was sent to jail for that. And then apparently when he was in jail, he used the law books and such and researched this and appealed, said, it's not right that I wasn't able to have a lawyer. So his appeal was successful and got up to the Supreme Court. And the Supreme Court said, yeah, you should have had a lawyer appointed. So the Supreme Court says, yes, you have a right to a lawyer if you can't afford it, and that this right applies to the states as well. So the Supreme Court, it didn't say you're innocent, but it says you have the right to a new trial with a lawyer representing you. And in that new trial, the lawyer was able to show that the witness was not credible. And in that case, there was only one witness against him, and the lawyer could, by cross-examination, show that that witness wasn't credible, and he was found innocent in his retrial. So, in this case, he successfully appealed. He got into trial, and was able to prove his innocence. So, in conclusion, the Sixth Amendment provides various protections for the accused during a trial. The right to a speedy public trial before an impartial and local jury, the right to be informed of charges against you, the right to confront or cross-examine witnesses against you, the right to compel witnesses to testify on your behalf, and the right to a lawyer or counsel to aid in your defense. And that covers the Sixth Amendment.